Good evening, everyone. My name is Kayla Williams. I'm a staff attorney with Community Legal Services, and thanks for tuning in to today's Landlord-Tenant informational session. I want to also give a thank you to Maryland Black mayors and the Prince George's County NAACP. Again, my name is Kayla Williams, and I will be presenting today on the eviction moratoriums, the different phases that the court is in, as well as the different types of landlord-tenant proceedings. So give me one moment. I'm going to share my screen with you all. I've created a little PowerPoint. Give me 1 second. Alrighty. Okay. Alrighty, so again, my name is Kayla Williams, staff attorney with Community Legal Services, and today I'll be presenting on evictions during COVID-19. So if you're new to tuning in, CLS is a nonprofit organization that provides civil legal education, advice, and free legal representation to low-income individuals throughout Prince George's County. Here's a list of some of the services that we provide. We have a lawyer referral program, a domestic violence wellness program, a foreclosure prevention project, a failure to pay rent tenant representation program, a family law clinic for the self-represented, a Latino access clinic, a workers' rights clinic, and a Suitland law clinic. So in terms of the court's phases, the court is currently in phase 2. They've been in phase 2 since November 30th, and they will continue to be in phase 2 until March 14th of 2021. What phase 2 entails, the court is still open, however, it's operating in a limited capacity. You are still able to file things with the clerk's office. They're only hearing emergency cases though, so keep that in mind. If you file something that's not necessarily considered an emergency, it may be postponed, the hearing may be postponed until a later date, but the court is accepting filings. If you don't want to physically go to the clerk's office, you can file in the drop box, which is located on the side of the courthouse in the commissioner's office. In phase 2, the court, as mentioned, is hearing emergency cases, but they're also hearing rent escrow cases, and we'll talk more about what rent escrow is in a few moments. Additionally, they're hearing emergency breach of lease cases, emergency tenant holding over, emergency wrongful detainer, and emergency motions on summary adjustment. The court isn't currently hearing failure to pay rent cases. They will resume hearing failure to pay rent cases in phase 4. We'll talk a little bit about what those are as well. All other landlord-tenant cases that are not considered an emergency will be postponed until after phase 2. If you need additional information about the court's phases or what they mean, here's a link that you can visit on the Maryland Court's website. So on March 15th through April 25th of this year, the court plans to move into phase 4. What that means is it will be expanding its operations to not only emergency cases, but to just landlord-tenant cases in general. They'll be hearing rent escrow cases, breach of lease cases, tenant holding over cases, wrongful detainer cases, and they'll resume hearing failure to pay rent cases. In a few moments, we'll go over what all of these different types of cases mean. After April 25th, the court anticipates resuming its normal operations and hearing all types of landlord-tenant cases, as well as other matters. So first and foremost, I want to talk briefly about some of the current eviction moratoriums and local protections. A few of the protections that I'll talk about tonight include the CDC eviction moratorium, which is a national moratorium. It applies throughout the country. We're also going to talk about Governor Hogan's order, which temporarily prevents evictions during the emergency resulting from a tenant who suffered a substantial loss of income. Of course, that's the Maryland eviction moratorium. We'll also talk about some bills that Prince George's County recently passed. And note, these moratoriums can be raised before a hearing or after a judgment has already been entered. If you have any questions, feel free to call us. I'll provide our contact information at the end of this. But if for some reason your landlord has already taken you to court, and you didn't get the opportunity to raise one of these moratoriums, there still may be an opportunity to do so by filing a motion with the court or by giving your landlord something. We'll talk more about that briefly. Okay, so what is the CDC eviction moratorium? This is an order or a moratorium that bans landlords from evicting a tenant for non-payment of rent. This moratorium extends through March 31st. Of course, it requires that the tenant meet certain requirements, and I'll provide a link to the declaration form that you'd be required to fill out and give to your landlord. But essentially, if you are unable to pay your rent, and if you're trying to pay your rent and if you meet certain financial qualifications, if you give a form, the CDC form, to your landlord, they cannot evict you for non-payment of rent through March 31st. Keep in mind, though, this moratorium is not automatic. It requires that the tenant submit a signed CDC declaration form to your landlord, and you may also want to bring it to the court. Understand that the CDC eviction moratorium does not stop rent from being owed. So your rent will continue to accrue. It will continue to be owed. This is simply preventing you from being evicted before March 31st for non-payment of rent. Keep in mind that even if you give your landlord a signed CDC eviction declaration form, you still may be summoned to court at some time. You want to make sure that you appear in court. And you also want to make sure that you bring a signed CDC form to court so that you can let the attorney for the landlord or the landlord know, as well as the judge know, that you are planning to use this moratorium and that you did give the signed form to your landlord. So it's very important to attend your hearing if you are summoned to appear and bring any supporting documentation, including eviction moratorium forms, with you. Also, keep in mind that the CDC eviction moratorium does have a section that says that although a tenant can't be evicted for non-payment of rent if they meet certain qualifications, the tenant may be evicted for other reasons, such as breaching a lease or something along those lines. So just keep that in mind. This bill is particularly for non-payment of rent cases. And so at the bottom of this slide where it says to access the declaration form, that's where you can find the most updated form, which doesn't expire until March 31st. So of course you want to read that very carefully. Understand that that declaration form, you are signing it under penalties of perjury. So you want to read it, make sure that it all applies to you. And if it does, you can sign it and give it to your landlord. Make sure, I like to tell tenants to keep a signed copy for themselves as well in case they need to go to court, and so that they have proof that they did actually give it to their landlord. So again, to protect yourself with the CDC moratorium, you have to give a signed declaration form to your landlord. Again, you want to attend your hearing if you are summoned to appear. And again, if for some reason a judgment against you was already entered for a failure to pay rent case, you still may be able to raise the CDC moratorium, but you'd have to file a motion and let the court know that you wish to do so. Okay, so the next moratorium we will talk about is a Maryland-specific moratorium. And this is Governor Hogan's order, which temporarily prohibits evictions. This is similar to the CDC moratorium, but it's also different. This moratorium applies to non-payment of rent cases, but it also applies to breach of lease cases. Also keep in mind that Governor Hogan's eviction moratorium, it currently has no expiration date. It's set to expire as soon as the state of emergency is lifted. So of course, we're not quite sure how long the state of emergency will be in place, but of course, since we're still dealing with COVID-19, I'm assuming it'll probably go on for several more months. So what this moratorium entails, it says that as long as there's a state of emergency declared, a court is prohibited from ordering an eviction if the tenant can show through verifiable means that their failure to pay rent is a result of substantial loss of income due to COVID-19. So that means that if a tenant shows that they've lost their job or they've had a reduction in hours or a lack of childcare, if they got sick, if they're taking care of someone, and for any of these reasons they've lost income, a significant amount of income, they can raise this defense. Keep in mind, again, this is not an automatic moratorium. You have to raise this in court. So it's important, again, if you are summoned to appear at a hearing, you want to make sure that you attend, because if you do need to raise this moratorium, you'd have to do so in court. Also keep in mind that this moratorium, it deals with this moratorium, this eviction moratorium took effect once the state of emergency was declared, which I believe was March 5th of 2020. So if you've been behind on rent since, say, 2019, it may be a little difficult to raise this particular moratorium. But if you can say, you lost your job in April and you were unable to pay your rent in May, and you've been trying to pay a little bit ever since, but because you lost your job due to COVID, that may be a little bit more persuasive in court. So just keep that in mind. Okay, so the next bill that I want to talk about, and actually I want to just go back really quickly to these. For the CDC eviction moratorium and Governor Hogan's moratorium, neither of them are going to stop your rent from being owed. Understand that the court may make a determination as to how much rent is owed. And once these moratoriums are lifted, the court may then, or the landlord may then try to act on the determination of rent that was owed. So just keep that in mind, that neither of these moratoriums are going to stop rent from being owed. They're primarily in place so that you will not be evicted in the meantime. The hope is that you're able to work out a payment arrangement with your landlord, or you can obtain some type of rental assistance. Okay, so the next bills we'll talk about are Prince George's County bills. So during the COVID-19 emergency, the Prince George's County Council passed several bills that affect tenants, and we'll talk about two of them tonight. The first bill is CB 16-2020. And it says that a landlord shall not increase rent for a tenant who suffered a substantial loss of income if that increase would take effect during the state of emergency and within 90 days after. So we get a lot of calls from people saying or asking, can a landlord increase my rent? Well, technically they can, unless you've suffered a substantial loss of income. So this would require you to affirmatively or to tell your landlord that you have suffered a loss of income. And if that is the case, your landlord cannot increase your rent as long as there's a state of emergency in effect. CB 16-2020 also prohibits a landlord from charging any tenant with any late fees or penalties as long as there's a state of emergency in effect, and of course within 90 days after. So regardless of whether or not you suffered a substantial loss of income, this bill prohibits a landlord from charging late fees or penalties at this time. The next bill is CB 78-2020, and it says that if a tenant has not suffered a substantial loss of income, that the landlord may increase the rent, but not more than 2.6%. That bill also says that a landlord shall not issue notice of a rent increase or late fees or penalties during the state of emergency and within 90 days after the state of emergency is lifted. And of course, we are still in a state of emergency. We're not quite sure how long that'll go on, but I'm assuming it'll go on for several more months. So before we talk about the different cases, I want to just give a picture of how the landlord-tenant and how the eviction process works. Understand that in Maryland, a landlord cannot evict a tenant without going through the court. And I'm talking specifically about residential property in these cases. So a landlord can't just say, hey, you're behind on your rent, I'm going to change your locks, or I'm going to remove your belongings until you pay me money. They can't do that. If a landlord wishes to evict a tenant, they must first file a complaint with the court, and that complaint is, it could be a failure to pay rent complaint, it could be a tenant holding over. We'll talk about what these different types of cases entail. But they have to file something with the court seeking possession of the property. After they file that complaint with the court, a hearing will take place. The tenant will be summoned to appear, and the landlord would be summoned to appear. They can both raise any arguments or defenses that they have, but in order for the landlord to prevail, they would have to obtain a judgment for possession. And additionally, they would have to obtain a warrant of restitution. Without obtaining these, the landlord cannot legally evict a tenant. So after the landlord obtains a judgment for possession and after they obtain a warrant of restitution, they must then contact the sheriff's office. And the sheriff is the one who oversees the eviction. So even after the landlord has attended a court hearing and even after they've obtained a warrant and a judgment, they still have to go through the sheriff's office because they have to oversee the eviction. So just keep this in mind. Okay, so these are the cases that we're going to go over tonight. We're going to talk about failure to pay rent cases, rent escrow, tenant holding over, breach of lease, and wrongful detainer. And I give a summary of what each type of case entails, and I'm happy to make this PowerPoint available to whoever needs it afterwards. Okay, so the first case, and the case that we'll spend the most time talking about tonight, is a failure to pay rent case. And our office deals primarily with these cases. Of course, they're not currently being heard in phase 2, but when the court moves on to phase 4 after March 15th, that's when these will resume being heard. So a failure to pay rent case is a case that's filed by the landlord in which the landlord is seeking possession of the property based on the tenant's alleged non-payment of rent. This case can be filed by the landlord's agent, or the landlord's attorney. These complaints may include base rent, meaning just whatever your rent is. They may include late fees. Of course, they can include late fees during the state of emergency, but before COVID-19, the landlord could include late fees in their failure to pay rent case. And sometimes landlords will include additional rent. I would encourage everyone to just review your lease and to make sure that if you see any terms listing things as additional rent, just pay attention to that. They may or may not request that in court. And keep in mind that all of these cases that I'm talking about tonight, I'm talking about in the context of a judgment for possession, meaning an eviction. I'm not talking about money judgments. These are all cases in which the landlord is simply seeking to get the property back and to evict a tenant. Okay, this is an example of what a failure to pay rent form looks like. So once the landlord files this with the courthouse, the sheriff's office will then serve the tenant with a copy. In Prince George's County, they typically post it on your door. Sometimes you may receive it in the mail by the court, but it's usually going to be posted on your door. The parts that are highlighted in red are the sections where your landlord is required to fill those out. If anything is not completed, those could be defenses that you could raise in court, because as a tenant, you are required to have notice of what has been filed against you. So just keep that in mind. At the top, of course, the landlord's required to fill out their information, their address. They have to fill out the tenant's information, their address. We'll talk about what this licensing means, but they have to indicate whether or not they have a rental license, whether or not they have a lead license. They have to list what amounts of rent that they're requesting for what months, any late fees they're asking, etc. They have to include all of that information. And of course, by receiving this, by being served with this, the tenant would be put on notice and hopefully will have the opportunity to repair. So if you do receive this, you want to make sure that you gather any receipts or any proof that you have paid, or anything that may help the court or may help your case. So in terms of the rental license requirement, in Maryland, there is a case that requires that in order to bring a failure to pay rent case, that the landlord must have a rental license, particularly if the county in which that case is brought requires that a rental license be had. So in Prince George's County, the purpose of having a rental license is your landlord is required to ensure that the property is safe and free from certain defects. The only exceptions to having a rental license are if the tenant is the landlord's parent, child, sibling, grandchild, or in-law, if the landlord is an active member of the U.S. Armed Forces, or if the landlord has been relocated for employment or education. The landlord is required to bring a valid rental license to court if they do have a failure to pay rent case. Also, there are certain instances where the landlord will only have a temporary license that may or may not be sufficient in court. Just keep that in mind. Okay, and next we'll talk about an MDE license requirement. So if a rental property was built before 1978, the landlord must certify that that property has been registered with the Department of Environment and that it's been inspected for lead paint and that it does not contain lead paint. This may be one of the defenses that could be raised in court if that section of the failure to pay rent case or filing isn't highlighted. Okay, so here's a list of some of the defenses to a failure to pay rent complaint. You could use one of the eviction moratoriums. You can indicate that the complaint is incomplete or unsigned, that the amount of rent requested is incorrect, that the complaint does not indicate what months or weeks rent is owed. You can indicate that the complaint wasn't filled out correctly, that the tenant's property address isn't listed. The landlord, if they're asking for future rent, they have to ask for that on the complaint at the time of filing. For example, if they file the complaint in February, they have to ask for March's rent. If they, if they say, for example, they file the case in February, but the case isn't heard until March. If they've only listed February's rent on the complaint, they cannot ask for March in court unless they also ask for future rent. So that may be one of the defenses. Additionally, if a tenant, the landlord has to fill out whether or not the tenant is in the military. And also if there's no personal knowledge. So if there's an agent or a witness that's present at court, but the landlord isn't present or no one with personal knowledge, that may be another defense. And under normal circumstances, before COVID-19, a landlord could request late fees. However, those late fees could not be more than 5%. So that could be another defense. Okay. Alrighty, so the next we'll talk about is the right to redeem property. So even if you do obtain a failure to pay rent judgment, keep in mind that you have the right to redeem the property, which means that at any time before an eviction takes place, you can pay to stay, meaning you can pay the amount that is owed, that's determined by the court, anytime the eviction takes place. So even if the sheriff comes knocking and say, hey, the landlord obtained a judgment, you still have the right to pay to stay. The only time you don't have the right to redeem the property is if the landlord has obtained 3 or more judgments against the tenant within the past 12 months, within the past year. So keep that in mind. Even if you do get a judgment against you, you have the right to stay. So it's not too late to try to get rent assistance, or it's not too late to pay, as long as you don't have 3 or more judgments against you within the last 12 months. Okay, so next we'll talk about rent escrow and what is it? So this is where a tenant has been complaining about certain serious defects in their property, and they've given their landlord an opportunity to repair. However, nothing has been done. So what rent escrow does is it provides tenants with a mechanism to encourage the repair of serious and dangerous defects, which pose a substantial and serious threat to the danger or threat of danger to the life, health, or safety of occupants. So keep in mind that in order to raise a rent escrow case, the defects in the property have to be substantial and have to be serious. It can't be minor defects such as cracks in the wall or cracked tile. It's not really hurting anyone, like lack of paint. Those aren't going to rise to the level of rent escrow. Some of the examples of what might rise to the level of rent escrow are fire hazards, lack of heat, lack of light, no electricity, no hot or cold running water. If your toilets aren't working, or if you don't have adequate sewage facilities, if you have an infestation of rodents in 2 or more dwellings, or if there are significant structural defects that may pose a harm to you, these are the types of issues that may give rise to filing a rent escrow case. Keep in mind that rent escrow cannot be asserted by a tenant who has 3 or more judgments within the past 12 months. So just keep that in mind. So as mentioned, for a rent escrow case, as a tenant, you're required to give your landlord notice of the defects and an opportunity to repair. So you can't assume that your landlord knows what issues are going on in your property. You have to give them some type of notice. And you have to give them a reasonable opportunity to repair. And what is considered reasonable, of course, is going to depend on the circumstances. So arguably, if you have a hole in the middle of your ceiling that's just leaking water and all types of bugs and rodents are getting in as a result, of course, that's going to require the landlord to work a little bit faster than maybe something else. There is a presumption, though, that anything outside of 30 days, so if you give your landlord notice of something that's seriously taking place in your property and they haven't done anything for 30 days, there's going to be a presumption in court that they've been given the opportunity to repair, but that time period is going to be considered unreasonable. So of course, if your landlord refuses to fix these issues after you have brought it to their attention and given them the opportunity to repair, the tenant then can file a rent escrow case. Also keep in mind, though, that the landlord may argue that they haven't been given notice. They may say that the issues that the tenant is complaining of are no fault of the landlord, but instead they were caused by the tenant or by the tenant's guests, or that the landlord was denied an access to fix the issues. Keep in mind, just as you have to give your landlord an opportunity to repair the issues, you also have to allow them into your home so that they can fix them. Of course, they should be coming in reasonable hours, so maybe between the time of 9 and 5, but you can't just say, I'm not going to let you in because for whatever reason. You want to make sure that if you do bring something to their attention, you allow them a reasonable opportunity to fix the issues. So once a rent escrow case is open, the tenant will be ordered to pay any rent that is owed to the court. Note that if the tenant refuses to pay the rent, or if they're unable to pay the rent to the court, that may be grounds to dismiss the rent escrow. Additionally, after the rent is paid to the court will order that an inspection take place. They'll give the tenant a number for the county inspector, and that inspector will come out. They may also do the inspection virtually. But that inspector will detail all of the defects. So you want to make sure that you're present so that you can point out all of the issues to that inspector. And that inspector will then submit a report back to the court so that the next time that you come back for your rent escrow hearing, the court will be able to see what exactly the inspector reported, what issues were found, etc. Keep in mind that rent escrow cases can go on for several months. It is the tenant's case, so they'll have the opportunity to close it whenever they wish. Ideally, the case is closed once the issues are fixed, but I have seen certain cases where the issues have gone on so long that the tenant just wishes to close the case and move. Also, I don't think I mentioned this, rent escrow can be raised at any time by the tenant, or it can be raised as a defense to a failure to pay rent case. So if your landlord were to file a failure to pay rent case against you, and if the reason that the tenant has not paid is because there are significant defects in their property to which they brought to the landlord's attention, but to no repair, this may also be raised as a defense. But keep in mind, there's no right to withhold rent in Maryland outside of putting it in this rent escrow. So just keep that in mind. So once a rent escrow case is open and once the repairs are made, the case will be closed. The landlord may ask for some of the money that's been paid into the court's rent escrow registry based on the repairs that were made by them. But the tenant can also ask for some of the money to be returned to them based on the time it took for the landlord to fix the issues, the severity of the issues, the amount or the lack of use of their home as a result of these repairs needing to be made. Generally, the court won't give 100% of the money that's in rent escrow to either party. They'll take into consideration the work that the landlord did, and they'll also take into consideration the issues that the tenant has had to deal with. But also, there is a section of the rent escrow statute that says that if the landlord has made no good faith effort to make the repairs within 6 months, that the tenant can request that all money be returned back to the tenant. This is pretty rare, but it is allowed in the statute. One of the things that the tenant can also ask for in a rent escrow case is the tenant can ask for the lease to be terminated. And the court will honor that. But keep in mind that if you do request that the lease be terminated, you have to make sure that you are able to leave and that you have a place to go. Because if you don't do that, if you tell the court, I want to terminate the lease, and you indicate that you're going to be out by a certain date, if you're not out by that certain date, the landlord can then ask for a judgment of possession, and they could try to evict you based on your assertion that you could be out by a certain time. And another type of relief that can be requested in rent escrow is you can ask for your rent to be reduced going forward. So if, for example, for the last 6 months, you haven't had the use of a certain room because of the significant defects, you can ask the court to reduce your rent to take into account that you haven't had access to a portion of the home in which the landlord had agreed to rent to you. So keep that in mind. Okay, so far we've talked about tenant holding over. We've talked about failure to pay rent cases. We've talked about rent escrow cases. Now we'll move on to tenant holding over cases. And so what a tenant holding over case is when the landlord is alleging that the tenant had a lease, that lease has expired, or that it was a month-to-month lease, that the landlord has given the tenant at least 1 month's written notice, and that notice must be given at least a month before the expiration date. And sometimes leases require more than a month's notice to be given, so you want to pay attention to that section of your lease. The landlord must also show that the tenant is still in the property, and the landlord must show that they've waited until after that notice period has expired before filing a tenant holding over case. So the unfortunate thing about tenant holding over cases is the moratoriums arguably don't really apply to tenant holding over cases. The eviction moratoriums primarily apply to the non-payment of rent cases. So unfortunately, if your lease expires, your landlord may try to file a tenant holding over case. Of course, if you need assistance with these cases, I would suggest seeking legal counsel just so that you can know your rights. It may be worth also trying to negotiate with your landlord to see if you can get more time, etc. But essentially, that's what a tenant holding over case is. If your lease expires, your landlord gives you notice, and if you're still in the property, they may argue that you're holding over. Okay, and next we'll talk about wrongful detainer cases. We generally see these when a homeowner or someone who has legal right to possess the property has given maybe a friend or a family member permission to stay in the property, but that person isn't paying rent. Essentially, that person is a house guest. If that homeowner or the person who's in possession of the property legally asks someone to leave and they refuse to do so, they may try to file a wrongful detainer case. So the person who's bringing a wrongful detainer case must show that they have the legal right to possess the property. So of course, if you're a homeowner, you want to show the court that you have a deed. If you are a victim of domestic violence and you've been granted a court order allowing you to stay in that property, you can also file this against someone who, say someone you're dating, but they're not a tenant, they're not paying rent, you just allow them to stay, but you wish for them to leave. You may also be able to file this case. This case is not to be filed against someone who is not a tenant, so just keep this in mind. Wrongful detainer, you're alleging that this person has no legal right to be in the property, that they're not a tenant, they don't own the property, they have, there's no court order granting them possession, etc. This is sometimes referred to as squatters' rights law. Okay, and next we'll talk about breach of lease cases. Essentially, it sounds like what it is. The landlord must prove that there was a valid lease, that a lease term was violated or that a lease term was breached. The landlord must give 30 days written notice of that violation. If for some reason the landlord is alleging that the violation committed by the tenant was serious or poses imminent threat of danger, the landlord is only required to give 14 days notice, but it's a very high standard to prove. They must also let that written notice period expire before filing the lawsuit. And additionally, that breach must be substantial and it must warrant an eviction. So these are the two prongs that are usually somewhat hard or maybe hard or difficult for the landlord to prove. Not only do they have to show that a lease term was violated, they also have to show that that lease term or that breach was substantial and that it warrants an eviction. Okay, so that concludes today's presentation. I've created a list of helpful resources. As always, if you have any questions or if you need some type of legal representation in a landlord-tenant matter, give us a call. We may be able to assist. We have our, feel free to go on our website at www.clspgc.org, or you can call us at 240-391-6370. And the additional resources are very helpful. If you would like access to this presentation or if you have any additional questions, feel free to reach out.